My name is Douglas Elliott. I'm a partner in the law firm of Roy Elliott O'Connor in Toronto, and I have been a very active Charter of Rights lawyer. Section 15 of the Charter of Rights is the equality guarantee, and it has been called the most difficult part of the Charter of Rights. Some would say it's the most important part of the Charter of Rights. It has had direct impact on the lives of Canadians, and I would say particularly on the lives of gay and lesbian Canadians. For example, we wouldn't have same-sex marriage today in Canada, in my opinion, if it wasn't for Section 15 of the Charter of Rights. All of the benefits that are enjoyed by same-sex couples in Canada today are really thanks to Section 15 of the Charter of Rights. The Canadian governments, in first instance, had a series of meetings where they discussed what was going to be included in the Charter of Rights. That's when we had the famous kitchen cabinet, where a deal was put together between three politicians that included Roy McMurtry, who surfaced later famously in a Section 15 case I was involved in. But once they had agreed, there were parliamentary hearings to hear from ordinary Canadians about what ought to be included in the Charter of Rights. And it was as a result of those hearings that some important changes were made to the Charter of Rights, including changing the list of grounds in Section 15 to an open-ended list. The petitions of the lesbian and gay leaders like George Hislop to include sexual orientation, those petitions were rejected, but we did get that tiny bit of movement to make it an open-ended list. That was directly in response to the public hearings. I must say that when the Charter first came in, I didn't hold out a great deal of hope for how judicial interpretation was going to apply the Charter, and particularly with respect to gays and lesbians. Our track record in the courts was bad. No easier way of putting it. The courts, interestingly, from the very beginning, accepted the fact that it was an open-ended list, and they also accepted the fact that because it was open-ended, that sexual orientation was an analogous ground under Section 15. In fact, I did a thorough search of the early cases in connection with the Hislop case, and I was unable to find a single case in those early years where a court had said that it was not included. We lost a whole bunch of the early cases, but we lost them because it was found that the discrimination was justified under Section 1, or because the law in question didn't actually violate Section 15 in the first place, despite the fact that sexual orientation was an included ground. The first case where we were completely successful, that is, they found there was a Section 15 violation and it was not justified under Section 1, was the Vasey case. The Vasey case was a big surprise, I think, even to people in the lesbian and gay community, because that case involved conjugal visits for prisoners. And of course, prisoners are not a very popular group in society, and neither are gays and lesbians. So the idea that the court would rule in favor of a gay prisoner was a pretty startling conclusion. But we had the good fortune to have Chief Justice Iacobucci as the Chief Justice of the Federal Court. And Chief Justice Iacobucci found that if the federal government was allowing prisoners to have conjugal visits with their partners, then they had to allow same-sex couples to have those conjugal visits just like opposite-sex couples. It was a very surprising and important early ruling because it recognized that same-sex relationships are just like opposite-sex relationships. One of the remarkable things about the progress of litigation over lesbian and gay rights has been the great success that we've had in the time that the Charter of Rights has been in effect. it's really surprising, considering that we were so unpopular that we could only be included by implication in Section 15 when it was drafted, that we've actually been the most successful group under Section 15. If you look back at all of the Section 15 litigation and the various categories, sexual orientation, physical disability, sex, race, and so on, the group that has had the most success in the history of Section 15 is the lesbian and gay community. It's a remarkable record. We are the gold medalists of Section 15. In fact, it's a record that we eclipse the next most popular cause, if you will, common law couples. We have an over 80% success rate, and they've had about a 60% success rate. So we won the Section 15 race by a country mile, and it's remarkable because we were so unpopular that we weren't even expressly included in the beginning.